very good morning to you, and thank you for keeping it NBS Television. You're watching NBS Morning Breeze, the unauthoritative current affairs show in the land. The topic of discussion this morning shines a spotlight on the UPDF Amendment Bill, which is to be tabled before Parliament today. The Minister for Defence and Veterans Affairs, Oboth, is expected to be laying the bill for the first time today in Parliament. But there are questions on why government was asking to have quorum in the House. What could be the scheme behind today's plenary sitting, which will be happening at 2 p.m. We shall be discussing this amendment and whether we are returning entirely to the old same court-martial bill or court-martial operations, or government in this has respected the Supreme Court ruling and is making amendments in regard to the expected. Critical to today's discussion, we shall be speaking to Medad Lubega Segona, who is a member of Parliament for Busiro, but he's also a seasoned lawyer. He has appeared before the court-martial. He has appeared in the Supreme Court, and he was a critical individual in the ruling or in the matter of Kaziguruka versus Attorney General, which nullified the trial of civilians in the General Court-Martial. What are the particular concerns in regards to this matter? We'll take a look at this story and understand why there is fear, why there are questions on why government is hell-bent on having civilians back to the General Court-Martial. Take a look at it. After close to a month on recess, Parliament is scheduled to resume on Tuesday afternoon. Top on the order paper is the UPDF Amendment Bill to be tabled as a third item immediately after the communication of the presiding officer signifying its importance. On the 31st of January 2025, the Supreme Court nullified the trial of civilians in the court-martial in a ruling which paralyzed the operations of the General Court-Martial, which was handling cases of more than 400 civilians. The Supreme Court found that the court-martial lacked jurisdiction over civilians, lacked tenets on the fundamental rights and human rights, and was unjust. And I quote, "The provisions of the UPDF Act constituting and providing for the trial procedure of the General Court-Martial, the Division Court-Martial, and the Court-Martial Appeal Court do not contain any or sufficient constitutional guarantees and safeguards for them to exercise the judicial functions with independence and impartiality, which is a prerequisite for fair hearing provided for under Articles 21, 28(1), 44C, and 128(1) of the Constitution." This was the ruling of the Supreme Court. Ali Bunken, commonly known as Nubian Lee, is a former prisoner of the court-martial. At the time of his arrest in 2019, he was just a musician and a friend to now NUP President Robert Kyagulanyi Ssentamu. We caught up with him in the studios to pick his overview on the UPDF Amendment Bill in waiting.
Try to take us back, we civilians, into the kangaroo courts is heartbreaking in the kind of environment we live in. And we truly know that these court-martials, the military court-martials, are used as a tool of persecution of people who are in the opposition or anybody who speaks against the regime.
Even with proposed amendments to have a court-martial committee composed of lawyers at the level of a High Court judge, Nubian Lee, as he is commonly known, does not have any hope in this. He says it shall still serve according to orders.
To tell you, I for one, have experienced this. Even the chairperson of the General Court-Martial does not have any powers to do anything. Everything is on instructions from.
As the bill comes to Parliament amidst mixed reactions of MPs treading off their consciousness, lawyer and Member of Parliament Medad Lubega Segona has cautioned the government against acting mischievously, indicating that the proposal to return civilians to the court-martial works against the Supreme Court ruling.
The first one is acting mischievous, and I mean acting in bad faith. Undertaking a conspiracy against the country. Re-establishing anything called a court-martial as a court of law is catastrophic. The entire country should stand against them.
Segona insists the bill is ill-intended against Ugandans and does not leave them with any options but to prepare again to go to court.
I don't want to let my cat out of the bag. Whichever way you look at it, we shall go back to court.
As the bill comes, what awaits to be seen is what the government picked out of the recommendations of the Supreme Court. So whichever way the bill comes, it will be a matter of court and it will be only ending up there. That's how justice will be served. That's how many lawyers believe they will get to the right table of discussion and get minds to meet and resolve the question of trial of civilians in the general court martial. The bigger concern is in the trial of civilians, but there are many other issues within this UPDF amendment bill. Is that just it? Is it what we shall be discussing only? What are the criticals or what are the underlying issues? Why are Ugandans declining the trial of civilians in the general court martial? Tracy and myself are going to be shining spotlight on this, but also we shall be speaking to Medad Lubega Segona, who is a seasoned lawyer who has been handling this. He says, yes, for him, it will be a matter of returning to the courts of law. More of the same. Why is the uproar so sound in regards to this bill?
We have seen what the court martial is capable of. We have seen the power that is so amorphous, so larger than life, that they are able to handle, civilians in these courts. But also, I think what gives me some bit of, confidence is the fact that analysts and those that are fighting against this particular predicament are looking at the courts of law. Could it be that the outcome of the Supreme ruling on the 31st of January perhaps, brought this relief or this respect back to the judiciary of we will fight this through the courts of law rather than go to the streets or otherwise? We are seeing a level of confidence in terms of those that are key to this, outcome, going back to court, saying we will go back to court. What does that say about the judiciary? Is it a boost? Is it a vote of confidence? What do you make of that?
Could it be just a vote of confidence? Maybe not, but amidst all odds, you need to have a balance on where you can't fall towards in case everything else fails out. And so it will be the judiciary, the same judiciary or the same courts of law that nullified the operations of the court martial earlier on. I think a month before the Supreme Court ruling on trial of civilians happened, there had been a ruling in the Supreme Court which said that the soldiers did not have a right to appeal in the civil courts of law if judged or if ruled in whichever way in the court martial, that they had to deal with the ranks and file or had to move to the court martial appeals court in that line. Now, the coming of this amendment bill is a result of that Supreme Court ruling. The question of the Supreme Court came from how unjust, they came from how impartial, how compromised, I don't know which better words we could use, but came from the questions that emanate out of a structure of UPDF where the court martial lies. Say, for instance, when we're dealing with the matter of Dr. Kizza Besigye and Haji Bedlo Tale in the court martial, what was the big question for the Senior Counsel Kalibala and Mpanga was the challenge of how the UPDF court or that court martial has to seek for guidance from the High Command in case they're making a ruling on each of the matters, depending on the interest.
Definitely.
Now, we are going to be subjected to the UPDF amendment bill, but also it means there's a particular document, I don't remember how it's called, but there's a particular, is it most probably a guide or it's a procedure. It must be a procedure of a kind that the UPDF works with, that guides also how that court martial works away from what is in the UPDF amendment bill. That was a matter of concern because this we're asking. At this point, we are asking to be referred to the civil courts, but you need to get a decision from the High Command. What's the interest of a High Command in this? Because you know that the prosecutor in the military courts is the military. Is the same investigator, is the same everything.
Judge, jury, and executioner, if you ask me, in this case. But also, I'm curious, Shamin, to find out what the Attorney General has been doing with this particular bill. He was given time to look at this bill as it was and make amendments to this. Is he comfortable coming back with this kind of a bill? Because if you ask me, has anything actually changed? Personally, I wouldn't say anything.
I don't know.
It's an overhaul.
I don't know when we begin to think about what your intentions for a nation are, when we get to think about what kind of spirit I am speaking to Tracy. How do I view Tracy when I look at her in the eyes? Do I see an enemy? Do I see Do I see a terrorist? Like the kind of person I see in you informs how I act. Now, the amendment, if we are in any way to go by what so far we have seen as the operations of the court-martial and what is coming through, the insistence to ensure that civilians, in whichever way, go back to the military courts, is us working in a new document, but working
with
backward.
the old guidelines.
Working entirely with the old law, because you are saying civilians who are found with military ammunitions, military attires, and everything that is military are subject to this law. That's what has been the very biggest challenge. And that's how Honorable Kabaziguruka ended up in court, because there was an allegation of him trying to do what? To take life of a whole president of a nation and issues to do with ammunitions. In 2019, these Eddie Mutwez, the Nubian Liz, and the Honorable Chagulanyi were taken to military court in Makindye after being driven far from Kalangala, Kasajagira, and then coming here to the military courts. These were taken to that court, charged having been found with about 4 bullets, we can say. 4 bullets. When we spoke to Nubian Lee in the days and until today, he recounts a story of how the bullets and the matter of the bullets that were put onto them as a case was never an issue that happened even when they were out. No, it happened, according to him, it happened when he was in prison. 2, he tells you a story of how every other individual who was arrested in the times of then was being put on a file of ammunitions and whatever. Now, this is more of the same for one reason. If myself, Shamim Nabakoza, have any affiliations to a soldier in any way, and maybe I am found closest to him, or I am his spouse, or I am his daughter, or what, and we are found in an environment where probably he could have any of the military stores, much as they are allowed, and doing contrarily, depending on who perceives it that contrarily, you end up before the court-martial. Not just that. If we are to go by what is being said about this very amendment, if you are a supplier to the military, say for instance you are a supplier of food or you are a supplier of guns, and you are found or you are perceived to be committing particular crimes, do you know you'll be subject to military law? So we are literally washing white linen in mud, but expecting it to be as clean as your top.
Absolutely, that is the case, but also for checks and balances, I'm looking at the situations where human rights violations are committed by men and women that are in uniform. The case has been of people who hold others in the basement.
How about when men and women in uniform get to be framed?
Exactly. That conversation is what Shamim will be getting into much later on with Medad Segona, who will be joining us this very morning on NBS Morning Breeze. Now we do take a break, but return shortly with much more of this conversation.